Miss Amy Lou Husted is at the podium. She is Deputy Director of the Public Defender's Office, along with Miss Lily Blad, defendant in this matter. The people are here and represented by their elected prosecutor, Mr. Scott Kerner, Agent Rolfe from Michigan Department of Corrections. On December 18th of the year 2025, Ms. Lilybad pled in this courtroom to count 4 possession of methamphetamine and count 5 assault and battery. As a result of that plea-based conviction, the Michigan Department of Corrections did prepare a pre-sentence investigation report along with the sentencing information report. I received a report from pretrial services. She's completed the program successfully. I also received a sentencing memorandum from Ms. Husted.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. Today, we're looking at 2 defendants, 2 methamphetamine cases, and 2 very different courtroom journeys, all under the sharp eye of a judge who clearly remembers everything. One defendant already had a second chance and lost it. The other violated probation in one of the boldest ways you'll ever hear. We're talking drugs within reach of children, allegations of dealing, and a probation violation that happened in the parking lot of the Department of Corrections. The stakes? Prison time. The question? Who still deserves mercy and who's out of chances? Let's get into it.
I've read and considered both of those documents. Ms. Lily Blad, would you raise your right hand with me? Do you promise that you will tell the truth, the whole truth, nothing but the truth? So help you God.
Yes, Your Honor.
Thank you. May put your hand down. Ms. Lily Blad, did you have a chance to review the pre-sentence investigation report?
Yes, I did.
Any changes you'd like to see made to the body of that report?
There are 2 minor changes, Your Honor, that I outlined in my sentencing memorandum. Do you want me to place them on the record, or?
Yeah, you should. You should, if you would, please.
So they hit the MDOC attached an older
It did.
PSI, and
Yes.
in that we need a couple of things changed. First, under the marriages, in the table, the children's boxes should say at the time the old one was, it had the ages at the time the old one was written.
Agent Rolfe?
Your Honor, it's my understanding that if it already went to court, we're not allowed to change a prior pre-sentence report.
But it's attached to our report, and they didn't. Aren't you like?
And see what they.
There you go.
I mean, my understanding was it's attached because like they didn't include from the family marriage history part in the new report.
I see your point. Give it a shot, Agent Rolfe. See what happens.
Yes, Your Honor.
Do you have any scoring challenges, Mr. Kerner?
Yes, Your Honor. There's no challenges to the PRVs. However, the people would challenge OV-15. We believe that should be scored at 5 points because of the paraphernalia, the scales, and the baggie that preponderates towards delivery.
Ms. Husted, your response?
Your Honor, my client indicates she was not selling or using the drugs. So, but I would leave it to the court's discretion.
Yeah, I know that might be your position, but when they searched her grandmother's car, law enforcement found 2 digital scales, multiple empty plastic baggies, and over 7 grams of methamphetamine. And so the court finds that those factors preponderate towards a delivery component, which warrants 5 points in OV-15. So that challenge would be.
This right here is a critical turning point. OV-15 refers to an offense variable in Michigan sentencing guidelines, and scoring it at 5 points instead of 0 matters. Why? Because those points increase the recommended sentencing range. The judge isn't just looking at possession anymore. He's seeing scales, baggies, and 7 grams of meth and thinking distribution. Even if the defendant says she wasn't selling, sentencing is based on what the evidence suggests by a preponderance, meaning more likely than not. That's a lower standard than trial, and it just pushed her guideline range upward. So ask yourself, if you were the judge, would those items scream personal use or something more?
Sustained. Any other challenges, Mr. Kerner?
No, Your Honor.
Ms. Husted, do you have any scoring challenges?
No, Your Honor.
Ms. Husted, add them up. I'm sorry, Ms. Rolfe, add them up.
Your Honor, the PRVs remain the same at 27, level D. Offense variables, total 5. OV level 1, and it remains at 0 to 17 for guidelines.
Okay, thank you. 0 to 17. Allocution, Ms. Husted.
Thank you, Your Honor. Your Honor, in this incident, my client was arguing with her teenage son and he hit her, so she hit him back. She then left the residence and then had police contact because he called the police. Your Honor, she regrets her actions on that day. She knows that she certainly could have handled the situation much better. She's the adult and she should have, stepped away from the situation rather than let it escalate to them becoming physical with each other. Your Honor, she has drug addiction and she also has some mental health issues. She needs treatment for both of those. She knows that. She knows that she's just going to end up back here again and again until she gets the proper treatment. She has done very well on pretrial services. They gave us a report saying that she's had successfully completed it. I do note that the recommendation is for her to serve 6 months subject to waiver for inpatient treatment. However, since she has done so well on her pretrial services, we would request that I know Your Honor is aware that our office works with clients and we can help get them into the inpatient. So we would already done so if it weren't for the fact that she had this hearing date. So we would ask that she be left out of jail and allow our office to get her sent into an inpatient program we can call Midstate with her and make that happen.
Thank you, Ms. Houston. Mr. Kerner.
Thank you, Your Honor. This is the defendant's second conviction for drugs. I'd ask the court to fashion a sentence that focuses on punishment deterrence and rehabilitation, Your Honor. Thank you.
Thank you, Mr. Kerner. Ms. Lilyblad, what would you like to say?
I'd just like to apologize to the courts. I had a relapse in the drug use, and it's not something that I want in my life. It's ruined it. So if I just ask for discretion and hope that you can believe that I can do the right thing.
That I do the right thing?
That I do the right thing.
Because I assure you, I will do the right thing.
Yeah.
Thank you. So I go back to the last time you were here on possession of methamphetamine, and that would have been in 2024. And on March 15th of the year 2024, you said to me, I have no desire to smoke. I'm cleaning up my life for my 2 children. That's what you said.
Yes, sir.
So I believed you. I bought it, hook, line, and sinker, and gave you an opportunity to have that felony taken off your record, and you didn't do it. You failed. You ultimately successfully completed probation, but you didn't get to 7411, and you got that conviction on your record. So move forward 2 years, almost 2 years. Here we are again, and this time it's much worse. I don't agree with the way your attorney characterized the incident, and the transcript of your plea doesn't either. You went to the apartment complex where your teenage son was. You were trespassed from that. You weren't allowed to go there, and you struck him. You struck him, and we called the police. You were pulled over driving your grandmother's car with your daughter's 8.
Yeah.
She's in the car with you. And here's what law enforcement finds. A zip-up bag was sitting between the driver's seat and center console within reach of the juvenile. The bag was open and observed there were 2 digital scales, a plastic bag which contained suspected meth, another small plastic bag inside the plastic packaging, a pack of cigarettes that contained suspected meth, a glass tube with a silver lid that contained suspected meth, several small empty Ziploc bags, and a tube labeled Skittles. The tube contained a syringe with brownish colored liquid inside suspected to be heroin. There was also a glass pipe with a dark residue. All in reach of your 8-year-old. And I'm telling you, 8-year-olds know. And I'm sure that 8-year-old knew exactly what you were doing and what you had. So did your 15-year-old for that matter. And you had over 7 grams of methamphetamine, which indicates to me that you're probably dealing drugs. So you had your chance of treatment with this court, and you didn't do so well. And this court is going to focus really on protection of society, namely your children, from you. There'll be some financial obligations you'll need to meet with us, Ms. Lilyblad. That includes a crime victims assessment in the amount of $130, court costs in the amount of $961. DNA fee? No DNA fee. We'll strike that. That's paragraph 40. And then a $118 state cost. And Ms. Lilyblad, you will receive a sentence to the Michigan Department of Corrections where you'll spend a minimum of 17 months, not to exceed 120 months. Against that sentence, you'll receive credit for 85 days. Agent Rolfe and Ms. Lily Blad's packet, please include a directive that she undergo substance abuse and mental health evaluation and follow the recommendations.
Yes, Your Honor.
Ms. Lily Blad, you have 42 days from today's date to request an appeal. If you'd like appellate counsel to assist you, you've got to make that request within that time. If you would initial the form acknowledging that you received the notice. Mr. Schmidt, best of luck to you, Ms. Lily Blad. Bill State of Michigan versus Corey Mrazek. Mr. Mrazek was last before the court on January 26th of year 2026. On that date, the court had advised Mr. Mrazek that his status on probation was in question because his agent made an allegation that he violated probation, namely using methamphetamine. Ms. Houston, you had a chance to talk to Mr. Mrazek about these allegations and his right to have a hearing?
I have, Your Honor.
How would you like to proceed?
Your Honor, it's my understanding my client's going to plead guilty.
How do you plead then to the allegations that you violated probation?
Guilty, sir.
What'd you do that makes you guilty, Mr. Mrazek?
I violated by reporting the probation with a cotton swab of methamphetamines, of using methamphetamines.
You use methamphetamine?
Yes, sir.
And you use that on purpose?
No, sir.
Yes.
Oh, yes, sir.
I mean, it wasn't an act, you didn't just fall and accidentally ingest it.
No, sir.
So
Nobody
it was an
forced me
intentional
to do
act
it. Nobody forced me to do it.
It was an intentional act to put that chemical into your body, correct?
Yes, sir.
All right. And you knew that would violate your probation if you were caught.
Yes, sir.
I find you guilty. Wait a second. We don't have a probation agent here.
Oops. Sorry.
Let's take a recess. I'm all about moving early when we can. The hearing's set for 10:30, and we just can't. It's not fair to proceed without the Michigan Department of Corrections. So we're going to take a recess and wait for them.
Okay. Sorry, Judge.
It's okay. No worries. State of Michigan versus Corey Mrazek. The case was not scheduled to be called until 10:30. Ms. Houston was very excited and wanted to go early, and we all ran in here and got together again and got on the record, and then the court realized that Ms. Hertel was not here from the Michigan Department of Corrections. You can't be in trouble for not being 15 minutes early. That really isn't your fault. And I said, well, time out. Let's take a break and wait for the Michigan Department of Corrections. It wouldn't be fair to proceed without them. She's here now. Thank you. Sorry about that. And what you missed, Ms. Hertel, is Mr. Mrazek had just pled guilty to using methamphetamine, which would amount to a violation of probation. Is that correct, Mr. Mrazek?
Yes, sir.
You, Ms. Houston, allocution.
Thank you, Your Honor. Your Honor, Mr. Mrazek has a drug problem. He has been struggling with it. He has been sober he's been able to achieve some amount of sobriety. He unfortunately had a relapse that resulted in this probation violation. Your Honor, we respectfully ask that you follow the recommendation of the MDOC in the report and also continue so that he can continue with his treatment for his addiction.
Thank you, Ms. Houston. Mr. Kerner.
We'd leave it to the court's discretion.
Thank you. Mr. Mrazek, what would you like to say?
I would like to continue my rehabilitation, sir, and continue with the probation and further no longer use methamphetamine so I can better myself so I don't have to come back in here or go to the Department of Corrections, sir.
Is there anything else you'd like to say?
No, sir.
Thank you. So I'm reviewing the probation violation report, and there's a lot of troubling factors. You were released from jail, called and said that you couldn't make it, you were in an accident. Come to find out you weren't in an accident, and your girlfriend reported that you were smoking methamphetamine in the parking lot of the Michigan Department of Corrections. I've never heard of a thing like that before. Who would use methamphetamine in the Michigan Department of Corrections parking lot? Well, in any event, you clearly demonstrated to the court that you're not interested in treatment and you're not interested in probation. So the court will discharge you from probation. Your probation will be deemed unsuccessful. To the extent you owe fines and costs, those will be reserved. We'll use our civil remedies to collect those, and you will receive a sentence to the Michigan Department of Corrections, Mr. Mrazek, where you'll spend a minimum of 15 months, not to exceed 240 months, and your credit will.
2 defendants, 2 meth cases, 2 chances at redemption, and both ending in prison sentences. In the first case, the judge emphasized protection of the children and prior broken promises, ultimately imposing 17 months to 10 years. In the second, a probation violation involving intentional meth use led to 15 months to 20 years, with probation deemed unsuccessful. Legally, the court focused on deterrence, public safety, and accountability. The takeaway? Prior leniency can absolutely influence future sentencing, especially when trust is broken. Rehabilitation was offered, but compliance is everything. Now we want to hear from you. Do you think the judge struck the right balance between punishment and rehabilitation? Or should treatment have come before prison in both cases? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Be 208 days. And Ms. Hartel, please include in Mr. Mrazek's package the Michigan Department of Corrections a direction for him to undergo a substance use evaluation and follow recommendations. Listen, this is not a life sentence. It's not a very long sentence at all. But what it is, Mr. Mrazek, and what I hope is that it's a shakeup for you to understand that you got to change. You got to change. You're going to kill yourself, or you're going to kill someone else. It's going to happen. It's too much. It's going to fry your brain up, and then there'll be nothing left of you.
Yes, sir.
So take this as an exercise, get some treatment. You're going to see what's waiting for you, because what's waiting for you ultimately is either the cemetery or a life sentence.
Yes, sir.
If you don't stop, that's it. It's not a long sentence, but I hope it's enough for you to have an eye-opening experience that, hey, I don't want to die and I don't want to go back to prison. That's enough of that. I don't want to do that anymore.
Yes,
so
sir.
hopefully it'll be a positive learning experience for you, at least to the extent that you'll never want to go back again.
Yes, sir.
You have some appellate rights. Mr. Schmidt's approaching with them. What I'd like you to do, sir, is initial the form acknowledging that you received the same. If you'd like appellate counsel to assist you with the appeal, you've got 42 days from today's date to make that request. Thank you all very much.